Okay, so looking at today's lecture in relation to express co-ownership and severance. So we're starting the first of two lectures on express co-ownership, bearing in mind that we are dealing with trusts here. We will not be exploring or covering implied trusts in any depth, so we're dealing with express co-ownership as the potential to be a standalone assessment question. So that's what we're dealing with in this session. We're going to look at co-ownership as a concept, but really understanding that the focus of any assessment area, apart from a brief consideration of an implied trust as a registered land problem, we are going to be considering express co-ownership as the potential for a standalone assessment question. So that unfortunately gives us some language usage that has the potential for confusing us. So we have to be able to articulate clearly in our minds the distinction between a joint tenant and a tenant in common. So I'll explore that language usage with you, but just obviously to bear in mind we are not dealing with a tenancy as in a tenant under a leasehold or a term of years absolute. We're dealing with the idea of holding. So coming from tenare, the Latin for hold, that's unfortunately the language usage we're left with, but we're not dealing with a lease. We are dealing with people who have bought land together, and it's just about how they are viewed then. We look at the four unities. So how do we determine that people have behaved one way or the other in relation to how they hold land together? What happens then if those people don't want to be what I refer to as in the brackets or in a union with each other? How do they sever? How do they take themselves out of that union or outside of those brackets and stand independently of the others? And we'll look at the forms of severance as well, whether you sever from the get-go, so whether you decide from the start that you want to stay outside those brackets and outside the union, or whether you want to sever at a later stage, or you are severed somehow through some act. So we can look at all of that. And then what I'd like to do in the next session is put that into practice. So we'll look at some examples as to how that stuff works, and we'll look at the Trusts of Land and Appointment of Trustees Act when it comes to a dispute in relation to a lot of this stuff. So we're building. This is one session out of two, and you're kind of going to need both to fully make sense of it, would be my advice. We'll then look at obviously the impact of such a severance. So what does that do to the relationship and or the share of the property as a percentage? So co-ownership itself, what we're looking for in co-ownership is that two people are holding land at the same time. They're holding an interest in land at the same time rather than one after the other. So we're looking at it happening at the same time, concurrent rather than successive. We're looking at their ability to share the land as co-owners. So whenever there's co-ownership, there's a trust of land under section 36(1) of the Law of Property Act 1925. And this would mean that therefore where there's a trust there will always be a division. Remember that wibbly line I referred to in the Flegg case of having people on the legal title above, it's the fee simple, absolute and possession, and then having people below as having an equitable trust as beneficiaries. And here what we'll be always dealing with is we'll be dealing with at times both parties either side of that wibbly line. On the legal title we will have people who have expressly purchased together, and then down in equity we will also have the same parties. So it's going to be almost like a mathematical equation where you're mapping out these parties and what happens to them. So what that means is that the property can be conveyed to multiple parties, the property can be sold to many parties, and the legal owners will hold the property on trust for the equitable owners, even if that's themselves. These people who have bought together expressly will state that clearly from the get-go. So we could have had situations like that before. We could have had any of our examples where people paid money in from the start, even in the formative assessment. you could have had her Bali's payment in, enabling her and encouraging her to therefore become an express co-ownership from the get-go. And you were given some justification as to why she didn't want that to happen. So we have also got a trust imposed in situations like that to simplify conveyancing. So obviously in conveyancing, what we're looking for is a transfer of the asset, and the ability to pass property over from one party to another. If we're just dealing with who's up on the legal title as the fee simple absolute and possession holder, then that is the person that is dealing with the conveyance and has the ability to pass the estate. In the eyes of the law, that can be more than one person, and they are express co-owners together. In situations, however, where we'd only have one person up there on the fee simple absolute and possession part, the true owner, the other person has an implied trust because of their beneficial interest and their payment in. So this would arise from actions of theirs because of their contribution or some sort of agreement given by the other party towards their interest. Could be a domestic situation. So the trust usually arises therefore to protect them in some way. We've seen that in Williams and Glynn and Boland. We've seen situations where trusts arise by implication or by construction of the courts. The purchase will be in a situation where the party who is under the trust has to be protected by the other's behaviours or from the other's behaviours at times. However, we're not dealing with implied trusts today. I really want us to just kind of focus in and hone in on the stuff that we're dealing with here when we are analysing and addressing express co-ownership. So, my preferred way of dealing with this, and it will look a bit like a maths question whenever I work through some of the examples with you in the next lecture, and also when we come to do the seminar together, which I would really encourage you to do, because if you're thinking about options for your coursework and you feel you've maybe missed something or something's not quite hit for you, this is a nice, easy, tidy area to work through if you just want to do it as a standalone question. So what I do is, in the brackets, I'm using those brackets to keep a union together. Previously, that person would have been the fee simple absolute and possession holder, and they still are. The difference being now that we will have more than one of them. So we can't split the legal title. The legal title has to vest with one person. Anyone inside those brackets as a joint tenant is entitled to everything, but they are a collective within the brackets. So whenever we're drawing this out, we'll have the legal title at the top, and the person that we would have recognised as the fee simple absolute and possession holder will still be there, but there'll be more than one of them, and we'll be putting them into brackets. Under section 1.6 of the LPA, that will always be a joint tenancy. However, down in equity, it's possible to refer to them as either a joint tenant, they stay in the brackets as a collective, or as tenants in common. So we're going to look at what those phrases mean in a moment, but I just want you to start to understand that I'm going to be visually representing it in two different ways. Joint tenants will appear in brackets. You'll have A, B, C, D up in brackets. Down in equity, on the equitable title, we could keep them in brackets still as a collective of one whole unit, the whole unit of the estate itself, or we can split them out into what's referred to as tenants in common. And I've put the full stops in there on purpose so that we think about them as separate. So joint tenants in brackets as a collective, tenants in common, separate entities keeping shares. Okay, so brackets means that you're referring to the whole thing as a union. Tenants in common, no brackets, full stops, means that we're dealing with shares of a property. Please, please, please don't confuse the language usage with that of a leasehold. We're not dealing with leases, we're not dealing with a term of years absolute, but unfortunately we're having to use this language of joint tenants and tenants in common. So we are looking at people who have bought property together. They are owners, they are not under a lease, but the language usage we've got is to articulate them as either joint tenants, which they have to be on the legal title, and then down in equity as either still joint tenants together, so one dies, it goes to the other, or tenants in common for separate shares that are divisible. They can be divided up into separate entities. Okay, so that's clearly what that means. A joint tenancy or joint tenants as a concept within express co-ownership means that the brackets keep the property as a whole or as a collective. They cannot split that. They cannot assign the property to somebody else outside the brackets. It has to pass down to all the other parties that are within those brackets. So all the other joint tenants end up taking over if they drop out of the brackets. So it's a kind of a finality of he who lives longest gets all. So if we have 4 parties, one dies, it goes to the remaining 3 if they have just chosen to be a collective. If they had wanted to be separate and operate independently of each other and have the ability to give it to the cat and dogs home or their sister or brother, they would not be joint. They should not have been joint tenants. They should have acted in isolation from each other and kept each other separate. So that's what we're looking at. When people buy a house together and they have to on the legal title be within the brackets, in equity they don't have to behave like that. They don't have to behave like a collective. They could always choose to be independent of each other and just operate on their own share. If they were to do that, they would be referred to as tenants in common. Tenants in common means that they are seen as all separate parties. So I gave you the example of 4 in the collective before. If we had 4 in the collective again, it would be A, B, C and D as separate entities, with each of them having their own ability to have 25% of the property and pass it on to whomever they chose. So if they wanted to pass their 25% on to the cat or dog's home, or their 25% to their brother or sister, they could do, because they're not in brackets like a collective. It doesn't automatically go to the others in the collective. Bearing in mind that all of this is happening down in equity, all of this is happening in regards to it as a trust, not in the eyes of the law. So it's not subject to what they call the doctrine of survivorship, where joint tenancy would be. Joint tenancy means that, yeah, he who lives longest gets all, and the brackets just basically shrink until you have fewer parties in them, potentially then one party, and all the others dissolve or drop away. So when you see a express co-ownership problem, you have a collective of people who have purchased land together, and those parties will then have all sorts of things happen to them, because you're having to determine whether they chose to be in brackets at the start, and or then whether they fall outside the brackets along the way, or something happens to take them out. So you see deaths, bankruptcies, fallings out, all sorts of things going on. So as I said, if I was drawing this out as I do when I'm in class, how I would draw it would be that I would have a very clear line between recognising in the eyes of the law the fee simple, absolute and possession holders up there in brackets as joint tenants. So we can have a union, we can have more than one person as the fee simple, absolute and possession holder, but we can have up to a maximum of 4. So the legal title could be held by one party, which is pretty much all we've been doing so far, or by joint tenants. you can only have a maximum of 4 joint tenants of full age. So that's section 34(2). They have to be of full age, and so therefore over 18, and you can only have 4 of them. And it's impossible for us to sever or to remove the brackets in the eyes of the law. In the eyes of the law, we can't have a half or a quarter or a third of a house. We only have a whole legal title. So that's not able to be severed. It stays as brackets, as a collective or as a union. Then if we think about that line that is creating a trust, so up top we have potentially up to 4 trustees. Underneath, and when we're thinking about equity, we can have as many beneficiaries as we like. So if everybody had bought a house together, we would have to have the first 4 on the legal title, and everyone else would then just be recognised in equity. So the equitable title could be held as joint tenants. They could choose to hold it as a collective and stay in the brackets, or they could be tenants in common for their own severable shares that they act on and operate. As well as that, down in equity, apart from the fact that it can be infinite and we could have more than 4, they can be of any age as well. So we can have any amount of beneficiaries we choose, and of any age. So we can talk about children down there as well if we wanted to. Okay, so in considering how people behave when they purchase the property from the outset, an understanding would be where they haven't expressly chosen how they want to be in equity, we might consider how they want to be seen. So usually now people are asked, as well as on the legal title, how do they want to be viewed in equity? What do they want to be able to do with their bit of it? Do they want to hold it as a collective, or do they want to be able to operate on their own share? And the effect of that would be, as I've said, in the eyes of the law, you would have all 4 parties, A, B, C and D, as a collective in brackets up in the eyes of the law. Down in equity, we could have as many as we liked. A, B, C, D and E could choose to be joint tenants together. Or we could have A, B, C, D, E all separate. There's no brackets, there is no collective, and they're each tenants in common for their own severable share of 20% of the property. They have a 1/5 of the land each in the eyes of equity. We can't have a 1/5 of the legal title. We can have a 1/5 of the property as a beneficiary. So say, for example, in either of those cases, either as in equity they had chosen to be joint tenants, or in equity they'd chosen to be tenants in common, we could consider what would happen if D died and wanted to leave their interest to X. What would happen in the eyes of the law would be D is no longer there and the brackets shrink, so we only have A, B and C as holders of the fee simple, absolute and possession. They are still the only parties who are able to convey or deal with any transaction in relation to the sale of the land. In equity, again, D is no longer in the brackets because they've died, and under survivorship the brackets shrink, and instead of being a collective of 5 they are now a collective of 4. As I said before, he who lives longest gets all. Now we'll look at what would happen if D had wanted to leave it to X, and whether the effect of creating a will could have acted as some form of severance. But we're talking at the moment as if from the outset they had chosen this. So if they'd chosen from the outset to be a collective, unfortunately it wouldn't be able to go to X, because D's death would mean that the brackets shrink and it goes from a collective of 5 down to 4 in equity. However, if D had chosen from the outset to be a tenant in common, then obviously X could step into D's shoes because they'd articulated from the outset that they were holding 20% of the property. They were holding a fifth each. So X steps in to D's fifth of a house. So that's the impact of what would happen from the outset with these choices. Usually, how it is viewed where people have bought property together is that they are viewed in equity to also be joint tenants. If they've expressed themselves in the eyes of the law as joint tenants, then they will be seen in equity to be joint tenants too. So brackets at the top, brackets at the bottom, they are a collective. Unless words of severance have been used in the document that created this, so either the sale transfer deed or some will that has passed the property onto them as a collective. So if they've bought it expressly as people who wanted to buy property together, if there were words of severance that indicated that they were thinking about themselves not as a collective, or in passing it down, a parent passing to 3 of their children, if they have passed it down in a way that indicates that it's not to be behaved as a collective, those will be seen to be words of severance. For example, in Payne and Webb, they refer to equal shares. In Lewin and Dodd, they refer to equally. And in Peat and Chapman, they refer to divided between. So this wording would indicate that in relation to it as a share or to be divided or some form of partitioning language, that they're not thinking about themselves as a collective or as in brackets. They're thinking about the ability to operate on it independently of each other. So that wording could act as severance from the outset and mandate that they are therefore joint tenants in common of their own individual share. It's obviously best practice for a solicitor to identify in the sale how the parties want to hold. That's what happens nowadays. But clearly, if property is passed through a will, that's something else that should be advised to a client who is creating a will as to how they expect the property to be handled after it's been transferred. Do you want it to stay in the family line so that it's a process of elimination, or do you want it to be able to be sold and partitioned, which is what it would be if everybody has a share? The other thing that would be looked at as regards articulating from the outset how parties want to hold the property together would be the 4 unities. This shows a clear difference between joint tenants and tenants in common in equity. All has to be present, otherwise they will be viewed to be joint tenants. So Lord Denning in Bull says, each tenant is entitled to an undivided share, each entitled to possession and use of the land. And that means that all these 4 unities have to be present in order for them to become joint tenants. So as regards possession, they have to all be entitled to equal possession and not split into separate parts of possession. So they have to be entitled to the same sorts of hold in land, all entitled to possess the land as freeholders, for example. Their interest has to be for the same duration, the same nature and extent. They have to have the same interest in land as each other for the same time period as well, which is T. It has to both happen at the same time through the same purchase or inheritance document, and title, that origin of the document, e.g. the transfer or the will. So all of those 4 unities have to be present in order to be considered to be joint tenants, because those are the things that would indicate that they are a collective, that they're entitled to the same form of possession, that their interest in that possession is identical, it happened at the same time, and it arose from the same document. And they will be tenants in common unless if they choose to hold separately. So thinking about where a tenant in common is presumed in equity, apart from those words of severance, we would have unequal contributions to the purchase price. So there's an indication that if people have paid in unequal contributions, then they aren't a collective. They are hopefully wanting just their share back. So if somebody puts in 80% and somebody puts in 20%, equity will presume that they are tenants in common for their percentage share and not within the brackets. If it's ownership for investment or speculation, it's obvious that it's not a thing that they are behaving like a collective as regards. It's an opportunity, it's business. If money is given by more than two lenders, or more than one lender, joint mortgagees, then the equitable presumption on that is that they are going to be tenants in common, not operating as a collective. And if the property itself is held for multiple business purposes, in Malayan Credit they looked at that as and gave examples of like a chiropractor and a chiropodist operating within the same unit or the same building. So in any of those situations, it will be that equity will presume that they are meant to be operating on their own share, because in none of those situations would people be wanting to behave like a collective. So that's how you look at severance from the outset. If people have chosen to sever from the outset, then they should tell their solicitor and be clearly a tenant in common. We could look at those words of severance. If the four unities are present, they will be deemed to be joint tenants because they will be aligned as a collective, unless any of these equitable presumptions are evidenced, and then they're more likely to be tenants in common as a presumption under equity. Okay, so if we look at this as an example base and think about whether these people, sorry, that JT should have brackets around it. So let's consider whether they are joint tenants or tenants in common, understanding that all of this is down in equity, not of the legal title. A and B buy a house. So in that scenario, you would definitely have A and B in brackets on the legal title as joint tenants. They would be two parties in a collective buying a house. Each contributes a half of the purchase price, and there's no express declaration of a trust in the transfer. That means that the parties have not stated whether they want to be joint tenants or tenants in common in equity, but there's equality of contribution. So if we have that situation, A and B appear to be or would have to be joint tenants in the legal title. Down in equity, there are no words of severance that we're told of, so they haven't tried to sever themselves. You look at the four unities of possession, interest, time and title. If they've bought the house together, they have the same possession and interest. If they bought it at the same time and it arose through the same title document, then the four unities are present. And that would be, you'd articulate that under Bull and Bull. Then you think about equitable presumptions against them being joint tenants, and there aren't any of the key ones there. We don't have an unequal contribution, we don't have joint mortgagees, we don't have it being used for investment, and we don't have multiple business use. So they would appear to be joint tenants in brackets down in equity also. Next example, A, B and C buy a house. A pays a half, B and C each pay a quarter, and there is no express declaration of trust in the transfer. Again, in the eyes of the law, the legal title, we would have joint tenants. In brackets, up top, we would have A, B and C as a collective within the brackets. We move down into equity and think about how do they mirror down as A, B and C in the brackets. Well, don't appear to be any words of severance. Could argue the 4 unities because they've bought a house together, same possession, same interest, same time, same title. However, they have contributed unequally towards the purchase price, so there's a presumption there that they would be tenants in common, each operating on their own share. So they would be separate, A for 50%, B 25%, C 25%. A and B buy a property for use as an office for their computer repair business. They each contribute half of the purchase price. There is no express declaration of trust in the transfer. We have 2 people buying together, no words of severance, so that indicates they could be joint tenants. We would look then at the fact that the 4 unities are present, possession, interest, time and title. They appear to be present, so as well as being joint tenants in law, we could map them down to joint tenants in equity. We have equal contributions, so that's fine. We do have it used as an investment, but it's just pure simple business use. So there would be an argument there that it's equitable presumption to be tenants in common because we do have people operating as an investment, but we don't have different business usage. So there is some room for argument as regards that one. So that would be how they wanted to be viewed at the start. However, in a problem question, you would consider that, but then you're also going to have to consider severance at a later stage, because there could be a moment where everything was okay and they did want to be in a partnership and a collective, but things go sour and then they choose to operate on their own share at a later stage. So that's where later severance comes in. What this does is this converts their joint tenancy into a tenancy in common at a later stage, but in equity only, bearing in mind you can't sever the legal title. So this is where they've started out as joint tenants, but they want to sever at a later stage. The reasons for doing that would be that obviously it allows them more freedom as a beneficiary, it allows them to operate on their own share, and it negates that survivorship drive that there is within joint tenancy behaviours. It means that they can allow their share to go to other people. They can pass it down. So they can't do this through their own will. They can't use their will document. We'll look at that in a moment. They can't use their will to give people their share. There has to be some understanding within the brackets that these people don't want to be within the brackets. It's not about them communicating always externally. It's about their communication towards each other, the parties within the brackets. Section 36(2), obviously we've covered the fact that we cannot sever the legal title, so that's not what we're dealing with here. We're dealing with the severance down in equity alone. But the process is also held in section 36(2), that being that the process is that it is done in writing. So the idea being that the communication in the brackets is key, that the parties are communicating with each other in that way, writing to each other of their intention to sever. Bearing in mind we've already looked at situations where people aren't held to that, where it's unrealistic a behaviour that they would write to each other. You're living in a house with 3 other people. Are you going to write to all 3 of them and tell them you want to be in the brackets with them if your relationship has so clearly deteriorated? that would be unrealistic. So as well as Section 36.2 of the LPA, we do still recognise a previous case that was good law and remains good law of Williams and Hensman. Williams and Hensman recognises that a person can operate on their own share. They can act in a way towards the others or mutually agree with the others that they don't want to be in the brackets anymore together. They don't want to be a collective. And we will look at both Section 36.2 and Williams and Hensman together shortly. What will happen then on severance once you move yourself outside the brackets is that you will then have equal shares on that severance, irrespective of whether you had unequal shares at the start. If you chose to be a collective and be joint tenants together, Goodman and Gallant say that what will happen is you end up with an equal share because you had your moment to articulate yourself as being separate and having a larger share from the get-go. If you didn't choose to do it at the beginning, you cannot then re-choose it at a later stage. So in Goodman and Gallant, we have a husband and wife who want to sever their interest into joint shares at a later date. However, there was a 3/4 to 1/4 split in terms of equality of contribution, but because they had expressed themselves as joint tenants, it meant that they were in brackets, they were a collective, and therefore they got 50-50 at a later severance. So severance at a later stage will mean that you get equal shares of whoever's in the brackets. The brackets shrink, you put yourself outside the brackets for an equal share of whoever was inside the brackets before your severance. And we will look at that in more detail in the next lecture. We will work through that as an example of mathematically kind of what that looks like and that movement. Oh, and we're about to have a quick look at some of it now, apparently. So we've got A, B, C, D as joint tenants, and recognising that A, B, C, D and E can be joint tenants, or you could have A, B, C, D, E as tenants in common for a fifth each or 20% each. Looking at the idea that we cannot sever the legal title. If D had wanted to sever at a later stage and leave their interest to X, then what would happen, as I said, is D's death shrinks the brackets down. Joint tenancy in law goes from 4 to 3. In equity, we would have A, B, C and E from 5 down to 4, or A, B, C, X and E if they were tenants in common. Ooh. So what if they severed at a later stage? If it wasn't death but severance, what would happen is D would move outside the brackets and become a tenant in common for his own share. Up here, D would move outside into being a tenant in common. The brackets would shrink and D would be able to leave his share to X, with the brackets closing down behind him. So in that situation, we're usually dealing with a house share. The ones that we've looked at and will look at coming up together are a group of people who have purchased property together. We will have A, B, C, D buying as a collective, and then various situations where they may or may not want to be in the brackets together, behaving certain ways. How then do they tell each other that they don't want to be in those brackets together? Well, we know that we have asked for writing under Section 36.2 of the Law of Property Act 1925. How do they then do that? Section 1964 of the LPA gives us a mechanism, an administrative procedure to be met with as to how that could be done. And that means that it can be left at the previous address, or the address that the joint tenancy relates to, or it can be registered, recorded, delivered letter. So in Re 88 Berkeley Road, we can see an interesting case where two joint tenants occupy the premises. One joint tenant serves notice on the other in writing. It was a registered letter sent to the property. However, the person who received the letter was the person who'd sent it, because they were living there and they didn't tell the other person. Oh, closing. Oh my goodness, my laptop's about to die. Okay, we'll get through this. So we have a situation where somebody has posted a registered, recorded letter to the property, but then they are the person who receives it, and in that case they said that notice had been served because it didn't matter that the other party hadn't seen it. The formalities had been met to mean that notice in writing was effectively served. The next cases we see are in relation to it being able to be left at the last known place of abode. So under Kinch and Bullard, we see that it's a possibility for the letter to be left at the place of abode, because obviously if people live there, they don't need to go through that palaver of sending registered, recorded letters. They can just live there and make it happen. In Kinch and Bullard, we have a husband and wife who had been joint tenants of the marital home. The wife started divorce proceedings and wanted to take herself out of the brackets. She wanted to serve notice of severance, as she was terminally ill. Sorry, bear with me. I'm just going to plug my laptop in. Sorry about that. So I can't even pause this. Right, anyway. So Kinch and Bullard, husband and wife, have been joint tenants of the marital home. The wife wants to start divorce proceedings, and she also decides to take herself outside the brackets so that she can do what she wants with her share, because she knows she's terminally ill and she doesn't want the brackets to shrink and him to end up with the property on her death. So she wants to avoid survivorship. Her solicitor sent on the 3rd of the 8th the letter indicating her severance. It was sent in the ordinary mail, not recorded, but it did arrive at the property. However, the husband had a heart attack within the time period of the letter being sent and it arriving. So it arrived on the 5th of August and she was there to receive it. She changed her mind and destroyed the letter, hoping obviously that if the husband died, the property would vest to her because the brackets would shrink and she would remain inside it. However, all of this obviously subsequently came out, and the courts viewed that posting had been sufficient, as the end result was that it ended up at the place of abode, and severance was effected from the moment it entered the property. So her wrongdoing in some ways came back to bite her. Her intention to take herself outside the brackets meant that they were both able to operate independently of each other. And we see that where there are any kind of grey areas about this stuff, that the statutory requirements under 196, 4 and 3 will prevail. In Grindle and Hooper, they tried to circumnavigate the statutory requirement by putting it into a contract that severance would only be possible if it was attached to a conveyance. At a later stage, they wanted to sever. The statutory requirement for severance was met, but it was not in a conveyance, which was the contractual method, and the courts held that the statutory requirements were not displaced by any contract, that statute would always prevail. So that's how somebody severs their interest and takes themselves outside the brackets from being a collective to being able to operate on their own share. We ideally want notice in writing. The best method would be to send it registered and recorded to the property, but it can be left there, obviously because people live together. In consideration of that, we also have Williams and Hensman severance. So this is recognition that people who are cohabiting may not behave that way. Williams and Hensman allows severance to take place in 3 ways. This would be where somebody is seen to be operating as if it's a shared, acting as if they're not in the brackets. Secondly, it could be severed by them all agreeing that that's what they would like to do. They don't want to be a collective anymore. And thirdly, there is some sort of course of dealings enough to indicate that the interests of all are mutually being treated as if they're separate from each other, so the brackets have effectively dissolved. And we can look at those now. An act operating on his own share is actually quite misleading, because sometimes it will be an act that happens to you upon your share. So if you choose to sell your share to somebody else, that will be you operating on your own share. You're very clearly alienating yourself from the other parties. So somebody else would come along, take your interest and become a tenant in common for your share. However, the other two, bankruptcy and potentially a mortgage, might be some form of alienation. So that's you either needing the money through the mortgage, or you being declared bankrupt and your interest transferring to what's recognised as a trustee in bankruptcy. So that's not actually you operating on your own share, that's somebody taking your share as one of your assets. So in those cases, Williams and Hensman severance will be enacted, and your share of the property moves outside the brackets, and that party becomes a tenant in common for your share. Mutual agreement has to be all parties. All parties have to agree that that's how they want to behave. This could be express, so all parties sit down and indicate expressly in writing that they don't want to be in the collective, which would be pretty much like notice in writing, or there could be some sort of express agreement indicated, but it can be implied that everybody doesn't get on. In Burgess and Rawnsley, it was implied because an oral agreement by one of the joint tenants to purchase the share of the other showed that the parties were thinking of the property as shares and not a unity. So this is 2 parties who are, as joint tenants, having a conversation about each other as a shareholder. In Re Woolnough, we see that a brother and sister as joint tenants, discussion in their wills to leave the property to each other, and gifts to a niece indicated that they did not think of the property as a whole. So again, this isn't just one will. You cannot give your share through a will if you are in the brackets, but this was both wills. So there was a mutuality there indicating that they were thinking of it as a share. A course of dealing is rarely used. It's not particularly helpful. The other 2 seem to be more helpful. If we're thinking about a course of dealing, we usually looking at situations where an agreement isn't possible because the parties are in discord, but they're acting in a way that indicates that they are separate from each other and operating outside the brackets. So it's technically possible was articulated in Burgess and Rawnsley, but implied mutual agreement is similar in that what you're doing is you're implying that the agreement is to be independent of each other because the relationship is broken down and everyone's doing their own thing. Okay, so what that does is the effect of severance would be that if D wished to sever from the recognition of being joint tenants, so in this case it was A, B, C and D as joint tenants have to be on the legal title in that way. A, B, C, D and E choosing to be joint tenants down in equity. If D wished to sever, it's obviously not possible to sever the legal title. However, their share moves them outside the brackets. It doesn't sever the brackets completely, it doesn't demolish the brackets. All it does is it takes them outside the bracket. And it would take them outside the bracket for a fifth in that specific moment. The other 4 remaining inside the brackets and still subject to the doctrine of survivorship themselves. As I said, that indicates that they are holders of equal shares. So please bear in mind that there's a lot to get your head around there, but that we're going to spend the whole of the next session really practically putting that into effect. We know what co-ownership is. It's the impact of people buying property together at the same time, not one after the other. We're primarily focusing as regards a standalone question for express co-ownership coverage within these 2 lectures. Unfortunately, we have the language usage as to whether they are articulated as joint tenants and tenants in common in equity, down in equity, not up in the legal title. To be joint tenants from the get-go, we'd consider the 4 unities. We looked at severance, the fact that they could have severed from the outset and chosen to be tenants in common, and then what happens after that if they sever at a later stage. So the impact of severance at the start, the impact of severance at a later stage, how they sever, so ideally in writing or under Williams and Hensman, and then what that does to the collective or the brackets when they sever. Thank you.